okay with that?
Hello. Antonio Yarbough. Nice to meet you.
So good evening, everybody. We're expecting Ken Thompson, but we're going to get started, and I think he's going to give some prepared remarks. My name is Zach Margulis Onema. I am the chair of the subcommittee on Brooklyn Conviction Review of the Criminal Law Committee of the City Bar. It's really an honor and a pleasure for me to introduce the panel tonight, and then I'm going to go sit down. So I'll say a word about Ken Thompson. Hopefully he'll come in before I finish. He earned his law degree at New York University Law School, where he was awarded the prestigious Arthur T. Vanderbilt Medal for his outstanding contributions to the law school community. He served at the United States Attorney's Office for the Eastern District of New York, where he successfully investigated and prosecuted a wide range of criminal cases and gained a reputation as an exceptional trial lawyer. After serving as a federal prosecutor, Mr. Thompson entered private practice at a prominent international law firm, then co-founded his own law firm, where he represented victims, everyday men and women, who had suffered unlawful discrimination or sexual violence. Mr. Thompson worked with elected officials and members of the clergy to convince the United States Department of Justice to reopen the investigation into the 1955 murder of 14-year-old Emmett Till in Mississippi. In November 2013, Mr. Thompson was elected the District Attorney of Kings County, Brooklyn, New York. To my far left is Rebecca Freedman, who's the Assistant Director of the Exoneration Initiative. She is a full-time Assistant Director. She's a graduate of the School of Law at Washington University in St. Louis. While in law school, she interned at the Legal Aid Society Criminal Defense Division, assisted in representing indigent criminal defendants. As a student, she was associate editor of the Washington University Global Studies Law Review. Rebecca Freedman has also interned at the ACLU in both the National Prison Project and the Campaign Against Racial Profiling. She received her undergraduate degree from George Washington University in Washington, D.C. Stephen M. Cohen, to my immediate right, is the Executive Vice President and Chief Administrative Officer and General Counsel of MacAndrews and Forbes Holdings. He joined the company in 2013. He previously served as the Chief of Staff to New York Governor Andrew M. Cuomo, who I think won re-election yesterday. And prior to that, served as Mr. Cuomo's counselor and Chief of Staff in the New York Attorney General's office. From 1998 to 2006, Mr. Cohen was a partner at a private law firm. He previously served as an assistant United States attorney for the Southern District of New York, where he was the chief of the Violent Gangs Unit, as well as a law clerk to the Honorable United States District Judge Stanley Sporkin and U.S. Appellate Judge Frank X. Altimari. He is a graduate of the University of Pennsylvania Law School and New York University. Jim Dwyer, to my left, is a columnist and reporter at the New York Times. He began writing the About New York column for the Times in April 2007. He has spent most of his professional life covering New York as a reporter, columnist, and author. He joined the Times in May 2001 after stints at the Daily News, New York Newsday, and several papers in northern New Jersey. In addition to his work on daily newspapers, Jim is the author or co-author of 6 books. Earlier this year, he published False Conviction, Innocence, Guilt, and Science, an interactive book. Using video, animations, and demonstrations, False Conviction explores the science of getting things wrong in everyday life and how that becomes errors in the criminal justice system. The book was produced by the New York Hall of Science. Dorothy Heyl, to my left, is our moderator tonight. She's a member of the New York City Bar's Criminal Law Committee in the litigation department of Milbank Tweed. Currently, Dorothy has done extensive pro bono work for the Innocence Project, writing amicus briefs in various states on the unreliability of false confessions and eyewitness identifications. She also chairs the amicus committee of the Criminal Law Committee and has just taken on a brief involving junk science and the shaken baby syndrome. An article she wrote on the Adrian Thomas case and the use of deception in police interrogations is about to be published by the Albany Law Review. Ronald Kuby, to my far right, has been afflicting state and federal prosecutors in trial and appellate courts around the country for over 30 years. His work has been responsible for exonerating 6 innocent men. While not his most important victory, his work recently resulted in the New York Court of Appeals declaring Penal Law 24030 sub 1 unconstitutional, thereby securing for all New Yorkers the fundamental right to be annoying. And last but not least is my favorite client, Antonio Yarbough, who's two to my right. Antonio Yarbough is a houseman at the Sheraton New York Hotel in New York City. He was born and raised in Coney Island. When he was 18 years old, he was wrongly charged and convicted 2 years later of a heinous triple homicide that occurred in Brooklyn. He was released this February after 22 years in Attica prison and is now making up for lost time, enjoying his freedom, and building the life that was taken away from him. And with that, I'll leave it to Dorothy. Thanks so much, everyone, for coming.
So welcome, everybody. Our topic is a new look at old convictions. I'm hoping DA Thompson will come and tell us about the present. Old convictions, looks to the past, and I hope a fair amount of what we're talking about tonight will be what we can do in the future. But I thought we'd just start with the obvious elephant in the room, the detective whose work kind of triggered a national attention to Brooklyn. And Steve, maybe you could start the ball rolling with your experiences with Louis Scarcella.
Sure. As was made clear a moment ago, I spent a bulk of my early career as a federal prosecutor in the Southern District of New York. And at the time, I was the head of the Violent Gangs Unit. In fact, that's how I got to know Ron.
It was a beautiful thing.
It was a beautiful thing. It really was. And what was interesting, and what I think people should stay focused on is, you know, there are certain cases that you say, and Scarcella's a great example of it, where you say, you know, well, there are convictions that are obtained after trial. They clearly have fundamental problems with those convictions, whether the testimony of the police officer or a confession that was secured and admitted in evidence is in fact inaccurate or worse, is always a problem. But to me, one of the most interesting situations I had was when my trial partner and I, Rich Zabel, indicted the Latin King case, and one of the cooperating witnesses was a Latin King named Louis Toledo. And Toledo, for us, was an easy defendant to turn into an accomplice witness because he had already pled guilty in Brooklyn. And he had pled guilty to a murder that took place in Bushwick. It was a Latin King murder. It was easy enough for us to take that murder federally, and because of the way the federal racketeering laws work, we had one or two predicate acts of racketeering that we were able to use against Louis Toledo. And as I said, he had pled guilty, so we had his allocution to use against him, and he immediately began to cooperate on that and a number of other charges. We were in a curious position when another defense lawyer who represented another Latin King came to us and said, my client would be interested in cooperating. I think you'd be interested in his cooperation, but there's a fundamental problem with your case. And he wouldn't tell us what the problem was. And ultimately, an honorable lawyer who we absolutely trusted, he came forward and he said, you know, you've got this Latin King, Louis Toledo, King Zur, and King Zur has pled guilty to a murder. I think he pled guilty in federal court and he pled guilty in state court. He says, and I know you're not going to want to hear it, but he wasn't there. And we said, well, how could it be that a guy would plead guilty twice and he wasn't even there? You mean we've got his role in the murder? He said, no, he wasn't there. My client was with him that night. It was my client's birthday. Zur was the only guy who had a car. There was a debate about who would go to Bushwick to commit the murder. My client, Nelson, said, he's got the car, it's my birthday, we're going to go together and we're going to leave. And that's the way it's going to be. And off they went. And the next day he heard about the shooting in Bushwick. And it was one of the strangest experiences I had as a prosecutor. We brought in this guy, King Zur, and began what was almost a reverse type of debriefing. Are you sure you were there? Are you sure you committed the murder? And ultimately, we broke him down. The guy became unraveled and admitted, in fact, he had lied and he wasn't at the murder. Now, he had pled guilty twice. And so we want to get this right. He wasn't there. A good part of the case involving that predicate act of racketeering now had real problems. But the first thing we wanted to do was withdraw Zer's plea in federal court, which we did. But now we had to deal with the state plea. And we couldn't understand how it was that he came to even plead guilty. And it was a long story about how he was picked up on a number of offenses. He was debriefed repeatedly. Ultimately, it became clear that they believed, the cops believed, and one of those cops was Detective Scarcella, that he had been involved in the shooting in Bushwick. The way he was questioned helped him understand what happened that night, and slowly, grudgingly, he began to admit to participating in a crime where he wasn't even in attendance. The Brooklyn DA's office's position was, what do you mean you want the plea back? And by the way, I'm not so sure that wouldn't be my position if somebody came on one of my pleas. What do you mean you want the plea back? He pled knowingly and voluntarily. This isn't even a case where his confession was offered at trial and he denied it and said he was coerced. He pled. And ultimately, after 6 months of fighting, it was the strangest fight that it was really Rich Zabel who went over and did the heavy lifting, they gave us the plea back. But what was interesting to me looking back on that case, given everything we know, is you get a sense of what the repercussions are of not just bad but corrupt police work, and how it doesn't just feed an individual case and an individual trial, but how it creates situations like this guy, Louis Toledo's, where he was forced to go, and frankly, the federal prosecutors were forced to go and say, the guy didn't just confess to something, he pled guilty to something he didn't do. And to me, that is one of the examples of what ends up being so difficult in these areas.
So it's a false confession case, right?
Well, you know, most people think of a false confession case as a guy confesses falsely, goes to trial and confession is offered against him, and then he's got a dilemma about whether he testifies. This was a false confession coupled with a false plea.
Which probably isn't all that unusual. But anyway, Ron, I think you're sort of a specialist in Scarcella, right? I think you have a good number of those cases now. And you met him back in the 90s?
Yeah. I mean, I was so captivated by Brother Cohen's story, because what I was expecting to hear at the end was, and as a federal prosecutor and the head of the violent gang unit for United States Attorney's Office for the Southern District of New York, a not inconsequential position, once I found out that this guy, Louis Scarcella, was coercing people into pleading guilty, that's when I started the federal investigation of him. But that was not when the federal investigation started. Not then, and not ever. And it's funny because I think this was probably, what, 96, 97, Steve?
Thereabouts, maybe a little earlier, but right around there.
Yeah, right around there. Because at that very time, I was busy cross-examining Detective Scarcella in another sort of classic Scarcella murder case. And again, I won't bore you with a lot of war stories about it, because we all have our stories. But my impression of Scarcella at the time was, this guy is a fantastic sociopathic liar. And he's totally charming. You know how defense lawyers, we have a tendency, whether we admit it or not, to live vicariously through our clients. You know, we can be like Hell's Angels or terrorists or gang leaders or mafia dons or something, without actually the sort of downside risk of that, early retirement, leveraged buyout, that kind of thing. Well, prosecutors actually do the same thing, because they're just kids out of law school too. I mean, they're not part of the street. And so when, like, Louis Scarcella, sort of prince of the city, blew in with his cigar and his hair and his attitude and his smile and his charm, you know, the women loved him, all the young male ADAs sort of had a bromance with him, and he was incredibly charming, despite the fact that everybody could see that he was lying. And I went back and I looked through my cross-examination in 1996, And I'm cross-examining Scarcella about Alan Bloom. I'm cross-examining Scarcella about David Ranta in 1996. I don't even remember, quite frankly. Years of drug abuse have robbed me of my memory of where I even got that information. But I have to say this, if Ron Kuby knew in 1996 about Alan Bloom and David Ranta, surely it was not classified information. And I think that what Steve, perhaps more unwittingly than he intended to, perhaps not revealed, was not just, this is not just one bad guy, although this is the baddest of the bad guys. This is an institutional failure at all levels to take action.
Okay, Rebecca, I think that you've had some experiences that suggest what Ron's saying. It's not just one guy, right?
Sure. I mean, before the news about Detective Scarcella really broke, our organization had a number of cases dealing with his partner, Detective Chamil, and he was really on our radar as a bad cop as well. He had actually, in one case that we litigated, fed a witness a statement to implicate our client. It was the single piece of evidence that got our client involved in the case. In another case, we believe he may have perjured himself at a retrial to secure a conviction. So, I mean, I think the problem was many detectives, and that these are just the ones that are kind of coming out now.
So, but still, I think that he's become larger than life for us, maybe because the New York Times has covered him so extensively, so many articles. We have a New York Times writer here. But, Jim, it's your view that he wasn't alone, right?
I want to talk about Air Canada crashing in 1983 when it was flying from, I think, Dallas to Toronto. And they started smelling some stuff in the cabin. The passengers were complaining. And the pilot said, oh, gosh, it's the usual thing. Somebody threw a cigarette butt in the garbage can, because back in those days you could do it in the bathroom. And so the flight attendant, one of the flight attendants went back and squirted some stuff on it, and it doused the flames. But the actual wiring in the plane had already got so hot that it was starting to burn up. So the elevators, the things on the planes that keep them up and all that, they lost all their power. And the pilots eventually landed, made an emergency landing, and just as they got down, the interior of the cabin lit up. And so 23 of the 46 people on board died. So now when you go on a plane, you hear, there's now, of course, smoke detectors in every lavatory. If you disable them, you're warned ahead of time that you'll be prosecuted. There's automatic fire extinguishers that will go off if they get some smoke in there. And there's lights along the corridors in the plane because they found that people died getting out, trying to get to the exits. And there's a few other there's better instructions on how to open the door because the real problem was people got suffocated. So there's a very smart lawyer named James Doyle who's been writing a lot about false convictions, and he calls them sentinel events. And he compares what hospitals do and what the National Transportation Safety Board does with sentinel events, takes them, studies them, disassembles them, looks at them, and sees what they mean. And no one who has looked seriously at the criminal justice system in New York in the 1980s and 1990s can think that Scarcella was anything but a sentinel event, and that he was part of an ecosystem that tolerated witnesses going, single witness ID cases on very shaky evidence, informants quickly turning around. Ron Kuby and I have encountered each other over many times over the years, but one occasion was around 1990. When did I go to work for the Times? It was in 2001. Ron had two clients named Faison and Shepard, who had gone up for a murder on the testimony of a single informant for the precinct. I think it was the 78th precinct, yes. And the detective who unraveled the falseness of this case was named Michael Race. And he had recently retired from from homicide investigations in Brooklyn and I believe in East New York. And he was in the adjacent precinct. And he instantly recognized the failures of this prosecution because, as he said to me, I did 750 homicide investigations in my career. Only one of them was done the right way, A to Z. Okay? So that's actually on the front page of the Sunday New York Times in May of 2001. If anybody ever needs a Mike Race quote, there you go. Mike Race did 749 half-assed homicide cases. I don't know how many Scarcella did. I don't know how many other people working around them did. How many defense lawyers went to sleep on the job, weren't aggressive enough in going for alibi witnesses, going for alternative versions of the story. How many prosecutors tolerated what was clearly false testimony or false reporting from their detectives. How many judges waived confessions and witness identifications through the system. This was not, Scarcella is nothing but a sentinel event. He is not the story, he is a story. And I think we will misdirect ourselves badly if we do not look at his episodes and others in the context of what was going on in criminal justice in New York in the 1980s and 1990s.
Mm-hmm.
Now? Yeah, okay. The DA has arrived, and he will now, is he coming? Great, okay. So he's going to say speak at the end. Okay, good.
Am I doing something wrong?
Yeah. You know,
Look at me like I'm doing something wrong.
Okay, so Jim has expressed his view in some metaphors and has talked about Scarcella as a sentinel event, one that on the phone today he told me about, say, a drug in a hospital that's on the shelf and people, you know, are dying from it, and then they research and they find there is a problem here, and it's not just that this one drug was on this shelf, but something is severely wrong and has to be addressed. So I'd like some thoughts. I know researching this, I looked up the conviction integrity panel that came before in Heinz's administration, and he said the problem was that there were just so many murders and the system was overwhelmed. But I think, Jim, you were telling me you thought that one of the things, just a constellation of causes for why we have the problem that we do. And you mentioned, I think, guilty pleas?
I think there's an enormous, I wrote about a guy last week who got arrested because he was a passenger in a car and there was residue of marijuana in a pipe that was seen in the center console, allegedly in plain view. And the man's been out, he was a school bus driver because he was a passenger, with the contraband, he's got whatever that liability is that you get from contagious misdemeanor marijuana possession. And so for him to get on with his life, right, he obviously, to me, the search cries out for a suppression hearing. Nobody in his right mind could believe that the cops pulled over the car and that the driver, if he did have this marijuana pipe in the center console, did not have the wit to close the lid on the center console. It just defies any expectation. But, of course, there is not going to be a suppression hearing. When people try to have suppression hearings in these minor cases, in these particularly in the marijuana misdemeanor cases, I think there was a study done by the Bronx Defenders. They had 75 cases in which they sought to have suppression hearings. They could not get to one because the cases kept getting rolled over and rolled over and rolled over. So there's actually no justice system at that entryway. And so people take pleas to get on with their life. Typically in these marijuana cases, they get the adjournment and contemplation of dismissal, which means they have, a year of probation. In the case of the guy I wrote about last week, a school bus driver, he didn't have a year. He can't afford a year because he's out of work every day that he's on this limbo status, right? So the guy makes $40,000 a year. He's been out of work for 2 months already. He's already paid $7,000 or $8,000 in forfeiture for an illegal search that there is no justice system here available in New York City to defend him.
So the problem with lack of resources and the no suppression hearings leads to smaller problems for the low-level crimes, but you're saying...
Yeah, I mean, why? I don't understand why the district attorney's office, which have tolerated for the last 15 years what are clearly an epidemic of illegal searches when it comes to these marijuana cases. We've had 50,000 arrests for allegedly people openly displaying or burning minuscule amounts of marijuana that they're elevated into a misdemeanor because they're supposedly being openly displayed. Where we have 5 district attorney's offices. They have budgets in the hundreds of millions of dollars when you put it all together. And why are they letting these cases go through? I don't understand that. Why are the judges in criminal court tolerating this?
Okay, Steve, do you have a sense of what the causes of the problem of wrongful convictions in the city is? You can pass your time to you want, or you can answer.
Look, I don't know what the causes are, and these are complicated issues, and we're already talking about 2 different things. I think. I mean, one thing we're talking about is the quality of convictions to begin with, and I don't think there's anyone on this panel that really is here in a position to address that. The federal system and the state system are different. Both systems make mistakes. I think the biggest problem is how you ferret out those mistakes, ideally before the harm is committed. But then the second issue is, what do you do once the harm has been committed and you now have a situation in which you believe there was a wrongful conviction, which is, in a way, a problem you don't want to have, but clearly a problem we do have. And the thing that I have spent some time dealing with after I left, or frankly it started when I was in the U.S. Attorney's Office, was the problem of self-correction of the criminal justice system. And there are certain realities that it is very difficult for prosecutors and the institution that make up prosecutors' offices to face. I mean, you ask any prosecutor if innocent people are convicted, and they will say to you, yes, of course. And then you ask them, have you ever convicted an innocent person? And they will say, me? No, of course not. Now, that pretty much sums up the problem, if you think about it, because the people you're asking to review the convictions, and in just about every instance I'm aware of it, and I think many of them are great for starts, conviction integrity units, second look units, they're all great, but everyone I know about is embedded in the very office that obtained the conviction. And when you look at the problem and you say, well, what are the hurdles to getting it right, it always seems to me there are 3 hurdles. And I dealt for a decade with a case where I believe 2 men were wrongfully convicted. And I believed naively initially that it was just a question of bringing forward the believable, reliable information demonstrating that the conviction was wrong. And in fact, other men had committed the murder for which these 2 guys were sitting in jail ultimately for 13 years. But you're faced with 3 things. One is the system itself, for good reason, values finality. And so anytime you want to reopen something where there has been especially a jury verdict or a plea and an appeal, it's very difficult. And every prosecutor, in fact most lawyers, are trained to embrace the notion of finality. Life is short and cases come to an end.
Well, wait, Steve, before we get on to the problems with the conviction review unit, let's talk about root causes a little bit more and why we have this problem in our system of wrongful convictions. Ron?
Yeah, data are sort of cool because when we have data, we can actually figure things out. And it's interesting that so few people have tried to study the number of wrongful convictions and the causes of wrongful convictions. And usually when people are not studying something, it's because they really don't want to know the answer. Barry Scheck, however, in the Innocence Project, who's here in the audience, and a big shout out to Barry, he and the Innocence Project DNA exoneration people actually have started to collect data. And if I'm misquoting your most recent findings of your exonerations, you'll tell me. But mistaken eyewitness identifications contributed to wrongful convictions in 73% of the cases. Not the sole factor, but contributed in 73% of the cases. 27% of the cases, false confessions, wrong, just straight out false confessions, and in 60% of the homicide cases, false confessions. So we do have some data, and add with that Brady violations, which are sort of anecdotal. But we know, I mean, if we want to change this, we know what to do about it. Number one, double-blind lineups. The science is there. The science is conclusive. We can avoid almost every mistaken eyewitness identification with double-blind lineups. Number two, false confessions. We can videotape every encounter that the police have with a suspect from the inception of the encounter until the end where they give their full scripted confession. And number three, as to Brady violations and other discovery violations, as former Justice Yates has been proposing for the longest time, we can have open file or mandated open discovery. These are three simple things that we can do going forward to prevent wrongful convictions. But there is not a district attorney in the 5 boroughs who has actually implemented those three simple, well-recommended, scientifically acknowledged solutions. And why is that?
Okay,
Well, could I add one thing to what Ron just said?
That was sort of my segue to Brother Thompson there.
Just to add one thing to what Ron was saying about the data. So there's a terrific legal scholar named Brad Garrett who he's written law review articles in a book about, he dug into all this data. But one thing he did was look at 40 false confession cases. And one of the things that he found was that in 38 of them, these innocent people, right, 38 of the 40 innocent people were able to provide in the course of their confession details known only to the criminal or to the actual criminal or to the police. In other words, they were able to validate and verify their confessions through information that they shouldn't have had if they were actually innocent. Well, clearly what's happened is that their statements were contaminated somewhere along the way, inadvertently, advertently, however it was done, and there's no visible record of that unless the statements are interrogated. Unless the interrogations are recorded.
Right, so the taping of confessions is a major step forward that would help. Rebecca, do you have anything to add about the causes of wrongful conviction?
I do. I think it's a little known fact, but maybe not in our community, that of the more than 1,000 exonerations that we now know about that have occurred since 1989, the number one cause of wrongful conviction is actually witnesses lying. And eyewitness misidentification is, still a major problem, but witness lies actually cause more wrongful convictions than anything else, and particularly in homicide cases. And I think a way to deal with that would be to lessen the tunnel vision of investigators as they're investigating these serious crimes, because they focus in on a suspect, and then through their contact with witnesses and even the defendant himself, they can actually cause evidence to arise to implicate that suspect. And I think that that's one way that witnesses don't even necessarily know that they're lying, but they get, convinced through this process of investigation, and it causes a lot of perjury, false accusations, people lying about identifications, or actually being convinced themselves when it's not true.
So, Zach, would you like to tell Tony's story on false confessions?
Tell my own story.
Yeah, I mean, would you like to tell your story or not? I mean,
Sure,
because
sure.
Zach has told me Tony's story, and it's just horrifying. If you can imagine the worst thing in your life happening, your mother and sister and her friend killed, and you come home and find them, and then you call the cops, and then...
Well, so a lot been said here. I come to speak for the people who actually been wrongfully convicted. The sad thing about it, I was, through my attorney, Zachary and Philip, I was told that I was interrogated for 15 hours straight. Now, I'm 18 years old, never been in trouble with the law before in my life, no criminal record whatsoever. Come home, you find the most important people in your life taken from you in such a heinous way, and you go down to the precinct expecting someone to help you, and what happens is that it turns into even much more of a nightmare, you know. And so, being with the mindset thinking that, okay, these people are going to help me, and then come to find out that later on that that's not the case at all, that you are the primary suspect when you're the one who reports the crime. To me, it's horrifying, you know. And so what happened was, in my situation, it just got to the point where I couldn't take it no more. You know, 18 years old, I was 145 pounds soaking wet at the time, never been inside of a precinct before in my life, and I'm being interrogated 15 hours straight, and I'm constantly saying, no, I didn't commit the crime. No, I didn't commit the crime. No, I didn't commit the crime. And I was under my understanding was that once you say no, I didn't commit the crime, I would like to speak to an attorney, all questioning must automatically cease and desist. That doesn't happen. And the people in the district attorney's office know it. The people in the defense attorney's office know it. The people in the legal aid society know it. So everyone knows it. You know what I'm saying? And then you say, well, listen, I heard about there should be cameras put up in the precincts. And you ask, well, who would want to oppose that? Why wouldn't we want cameras inside of a precinct? Why? Because police officers don't do their job. And by the time the evidence gets to the district attorney's office, they know what the evidence is. So they don't, I mean, it's either they don't care or it's all about the numbers. This is how we view it, those who sit behind bars, 22 years, life taken away from you. You know, like, come on, I was a kid at the time. I'm 40 now. You know, and thank God I was allowed to get out just in time. Well, I think one of the main problems is that the DA's office has immunity. And as I sat up in Attica for 20 years in Attica, it mind-boggled me that, what do you need immunity for? You hold one of the highest offices in the county, you know, and then it hit me. You know, it's not about right or wrong. It's not about justice. It's about stacking the numbers up. Because the prosecutor in my case, who was a hell of a prosecutor by the name of Suzanne Mondo, she's a justice now. She's actually presiding over people's cases. And one of the sad things about it, I learned during the course of my lawyer Zachary took a chance on me and helped me win my freedom back, is that the medical examiner back then basically put me outside the mission of the crime. So you would ask yourself, well, why didn't they say, hold up, we have a kid here, a kid, mind you. He has no criminal background history. He has no record, period. You know, why don't we just say, hold on, let's go and take our time before we, you know, lock a kid up, charge him as an adult, and send him away to one of the worst maximum security prisons in the land.
So meanwhile, they decided that you did it. And
well, I mean, after a while, I mean, could you imagine just constantly being bombarded? You know what I'm saying, listen, no, we know you did this, and you say, no, I didn't do it.
No, I can imagine, because I've seen the videotapes of Adrian Thomas, who was interrogated for 9 hours, and I see how they can make you...
You get to the point, I speak for myself, I can't speak for nobody else who's exonerated, but it got to the point where they actually had me asking myself, well, did I snap, did I blank out, could I have, I know I didn't do anything wrong, you know what I'm saying? So, I mean, I believe if you take away their immunity and allow them to start being held accountable and being prosecuted the way they prosecuted me and so many other people, and then go to jail, and you know, maybe a lot of that will stop. Maybe they'll tell the officers, no, listen, you have to bring me something better than this. You know? I mean,
Yeah.
So unfortunately, there's a Supreme Court decision, right, that gives the prosecutors immunity.
the question I have is, why do you need immunity if you're there to uphold the law?
Yeah, maybe it will be reversed at some point, but right now there's a Supreme Court decision. And let me just say, the thing that makes Tony's story so shocking is not just that he lost his mother and his sister and then was falsely accused of the crime, but 8 years later, the person who did it was found because his DNA was in the dead body of another victim. And so while he was in prison, this man who killed his mother and sister was out committing crimes. And that's the real issue of wrongful convictions. I shouldn't say the real, it's the other side of it. One, there's somebody,
wrongful liberty.
yeah, there's somebody in jail who didn't do it, and the guy who did do it is out doing it more. Maybe he killed more than just that second woman, but they just found his DNA on the second one, right? So that's a real tragedy, the highest order. So Steve was starting to talk about...
Let's go back for a second, though, because these are sort of important issues, and I don't want to gloss over this, because let's put aside the immunity issue, and I agree with Ron, there are a number of fixes, but it's a mistake to say or to leave people with the impression that prosecutors are regularly looking to cut corners and aren't focused on trying to do justice. There are a number of people in this room, I know, who have served as prosecutors, both state and federal. And I think part of the issue is the ability of those offices where people are working to encourage people to recognize where there may be errors, where you may be going off track, where you want to question what you're doing as opposed to a drive to obtain a conviction. And my own experience is that just about everybody I worked with or supervised, in fact, was trying to do the right thing. Doesn't mean they did the right thing, doesn't mean they were properly supervised. But it's a mistake to simply say or lead people to believe that most prosecutors are out to rack up their stats and move on with their life. That, at least in my experience, and I suspect many people in the audience, was not their experience. What's, I think, a more difficult question is why it is that there are the kind of fixes that Ron has spoken about, and that, in my experience as a prosecutor, would in no way hamper my ability to do my job, why those things are not regularly utilized, and why they're not mandated by law. And that, in and of itself, I think, is a troubling question.
Right. I mean, you can understand why someone who's in jail for 20 years might be negative about prosecutors. And I think also, I mean, as far as the videotaping, we know it's been on Cuomo's wish list, but it's not happening, right?
I don't think, frankly, there are two ways to do it. You can mandate it by law. A prosecutor's office can stand up and say, or police departments can stand up and say, we're going to do this. And they haven't. And don't get me wrong. As I alluded to before, I was involved for over a decade in a case involving two men that were wrongfully convicted. I went into that believing that it would take about a year to get them out of jail. I thought that was a long estimate of how long it would take because I was part of the club. I was a former federal prosecutor. I had the evidence on my side. I was going to go in and explain the situation. They'd look into it, and the right guys would be put in jail and the wrong guys would be taken out of jail. 9 years later, we were still fighting and we had to go to a hearing. And the court thankfully vacated the convictions. One man was then deported based upon a plea of guilty he had taken to a gun charge. He had pled guilty to that gun charge, much like we alluded to before, because he had been convicted of a murder. What difference did the gun charge matter? And so he wrapped up that case. And the other man was then retried in one of the more curious trials probably that's ever taken place in Manhattan.
Okay, no more war stories. Okay.
No, but it's important, which is that the DA's office had in front of it the man who actually, two of the men who actually committed the murder. And yet they went forward with the prosecution. Now, that's a curious story. And it raises questions of institutionally and culturally, how do prosecutors end up thinking about their job, which they will say is to do justice?
Ron, before you. Ron?
Yeah, I just want to make a couple comments about what Steve said. I think it's true that you know, and I'm shocked to come to this conclusion after 31 years, that most prosecutors are really good, decent, honest, hardworking people who totally believe in the mission that they're carrying out. In fact, that's part of the problem, because they believe they're on the side of the angels. And once you're on the side of the angels, then things like complying with little niggling requirements which may prove you to be wrong when you know you're right become a hindrance. And when decent people are confronted with a mistake, a tragic mistake, that they've committed a horrible act that's taken away a human life for decades, there's two things they can do. They can say, oh, thank you, big, hairy Ron Kuby, for pointing out to me the error of my ways. I'm going to meditate on this so I can be a better person. Well, that's one response. Another response, however, is to say, I didn't make a mistake. You are the one who made a mistake. You're just in this for the money. This is phony. This guy's lying. This witness is lying. Because indeed, if you are a decent person, how do you live with yourself after doing something to a human being the way that Tony Yarbough was done? And last, I want to say that those of us who believe in the criminal justice model, that is, you do something wrong, either negligently, knowingly, or voluntarily, or purposely, you do something wrong, and you harm another person, you go to jail, you face some sort of punishment, you face accountability. That's our criminal justice model. I've never really liked it very much, as you know, but a lot of people here do. Why is that model never, ever applied to prosecutors? Just think that if we had a system that really had accountability, because this one doesn't. No one is accountable in this system except for the defendant, and he or she faces full accountability after trial or partial accountability if they plead guilty. But just imagine that prosecutors, and just imagine that cops actually face the same type of criminal justice sanction for robbing somebody of decades of life that regular people face for robbing somebody of $15 or $20.
What? Did you want to say something? Wait, I didn't think we'd have enough to talk about, but we don't have anywhere near enough time. So, Anthony.
Just real quick. I don't want to make leave here may have people thinking that I believe all prosecutors are, you know, the devil or evil or whatever. That was not my intent whatsoever. But thank God for Kenneth Thompson that I'm here today, you know what I'm saying, who's seen a wrong and he corrected it. And I thank him for that. You know what I'm saying? I honestly do. But when you talk about Charles Hines, I mean, he's been in office for what, I think for over 3 decades, and you don't know what's going on in your house, then there's something wrong with that. And that's what I was getting at. And believe me, there are some prosecutors, I'm quite sure he would agree, that they're the stacked numbers. Because there's no way in the world I should have been convicted of killing my own mother, sister, and little cousin. No way in the world. You know, so, I mean, that was one of my points that I was trying to make. And if I offended you, I apologize.
No, you didn't.
There's no offense.
No, fine.
All
You
right.
didn't offend anybody.
No.
We don't have much time, so Rebecca, the question is just, I mean, Steve was about to say, before I cut him off, that there's some institutional reasons that conviction review units don't work very well, having to do with, as we've just gone into, the defensiveness of prosecutors and...
Well, it's Ron's point, which is it's not just that conviction review units don't work too well. Prosecutors' offices are not set up to exonerate people.
Right.
And the problem is, if that's the world in which you live, and that is the perspective you grow up with, when you're suddenly asked to take a clean look at a case, it's very hard to do. It's very hard to do because somebody you worked with and probably somebody you respect obtained a conviction, jury said guilty, Court of Appeals said they're right. The second problem is institutionally, you're wired to believe you've done the right thing, and then you're dealing with a bureaucracy. And you know, let's face it, the prosecutors' offices can be great, can be wonderful places, but they're bureaucracies, and sometimes they operate more like DMV than they do an enterprise that's in pursuit of justice. And just because you carve out a number of people and you say you're going to now take the other side and have an honest look at these cases, life isn't that clean. It's not that simple. And one of the things that I've been amazed at over the last 15 years is that no prosecutor's office has said, you want real reform, fine. Somebody else will look at my convictions. And if there's a legitimate basis to question one, I'll give it, forget giving it outside the community of law enforcement. On the Manhattan DA's office, I'll let Brooklyn look at my convictions, and Brooklyn will let Queens look at their convictions. That doesn't get anywhere. And it's one of these instances in which there are easy ways to begin moving this to a system that would make us all feel a whole lot better and hopefully avoid the kind of tragedies that Anthony suffered from, but breaking through and having that happen. And look, you know, with what's going on in Brooklyn, it's fascinating, and hopefully we now have justice in Brooklyn. But justice is not reform. And it gets tricky when you start reviewing your own cases. And that's what I think we all have to really focus on.
Thank you. So it's hard work to do the conviction integrity units or review units, and there's also some very hard work that goes into the work of defense attorneys like Ron and like Rebecca and like Zachary. And Rebecca was telling me today about the kind of work that they do at the Exoneration Initiative that's similar to the kind of work that a conviction review unit would do, in the sense of looking back at convictions and seeing what ones are worth fighting about.
Sure. I mean, we focus on non-DNA innocence cases, which is a huge majority of criminal cases do not have testable DNA evidence. And as you can imagine, we receive thousands of requests from inmates, and most of our job, as with I think any innocence program, is culling through the massive quantities of requests for assistance and figuring out which cases might actually have a real innocence claim, and of those cases, which cases, you know, we could actually help somebody. And I think it's very important for any organization to have at least criteria and some kind of formula they use to evaluate their cases. I know we have criteria, which is generally a weak prosecution case at trial and some form of new evidence not heard by a judge or jury, or at least leads to new evidence, or some form of, you know, very apparent unfairness on the face that causes us to doubt the veracity of the jury verdict. And I think, you know, for us, we use students a lot. We also have an intake questionnaire, which is about a 20-page document that asks the inmates particular questions about their case, which is very focused on the causes of wrongful convictions, like misidentifications, false confessions, house informants, things like that. And using that, we go through a multi-tiered evaluation process, which, you know, is mostly objective. We don't usually speak to the inmate, you know, until we're very far along in their case process, because we want to have like a very objective view of the case. And it's through document requests and FOIL requests and eventually field investigation and then hopefully litigation that we're able to ferret out the actually meritorious innocence cases. And I guess a question we would have for, you know, Mr. Thompson and the Conviction Review Unit is whether they have any kind of protocol or criteria in how they're selecting their cases, because I know, like, we've managed to get through thousands, and, you know, we're still going back over and over through our caseload, and obviously there's no way to catch every case. Things are going to slip through the cracks. But, I mean, it would be interesting to know if there's some form of, you know, of criteria that they use as well.
Thank you. So before the DA speaks, we will take some questions from the audience. Mr. Russo?
I think we're talking about two different subsets of problems. One of them is very, very much, I mean, they're all worth our attention. You've got the Scarcella, you've got people who are lying, and people who are producing evidence that's not appropriate or withholding. But we're human beings, and the system is flawed because of that. When I was a federal prosecutor, but for the fact that something happened a week before a defendant that I was prosecuting was going on trial, that guy would have been convicted, and now 40 years later, he'd still be in prison. I shudder to think, and I didn't do anything wrong. The evidence was there. I had everything that I needed. Ron said earlier, we all have our stories. I'm not going to waste your time with it. But a fact came to me the week before I was starting trial. And fortunately, I had very, very excellent prosecutors. It was Dave Traeger and Ed Corman. And when that evidence was shown to them, they used what we called, in those days, a Form 900 to dismiss an indictment. It's probably the least used form in the federal law system. And that's what happened. But it was no one's fault. There was no negligence. It was just a human error. I don't know that we're necessarily talking about those kinds of errors. And not every wrongful conviction comes back to somebody having done it wrong. The things that are really glaring are the horrors where people actually have lied or produced witnesses, the things that we all know about.
So you think there'd be enough protections in the system to protect against innocent error? But anyway, any more questions? Yes?
If I could just maybe a question for a comment. We've commented on all of the things that bring about wrongful convictions and how we can stop them. However, the main thing is, how do we change the mindset of the individuals that are either prosecuting or reviewing these cases? I've recently been informed on a case that I submitted to an office that it's not our job to review jury verdicts. Now, if that's the mindset of the individuals reviewing the case that I've submitted, then no case will ever get overturned because it's wrongful, because most of them are jury verdicts. So how do we then address the issue of changing the mindset of the individuals that, yes, this happens, it happens more often than not, and we have to look at it genuinely and openly.
Any responses to that?
Well, yeah, we don't change their mindset. I mean, as Steve said, very, very eloquently and elegantly, it could be summed up as if when you're a hammer, everything looks like a nail. We're not going to be changing prosecutors' mindsets. What we should be doing is creating sanctions in the system for prosecutorial misconduct, the overt type of misconduct that will make people think again. I mean, look, guys, when I get a call as a defense lawyer from somebody who wants to retain me and he's going to pay me $30,000 up front, and can he send the money in installments of $9,085? I'm like, no, you cannot. Right? Because I know this is bad. I know somebody is going to be sanctioning me if I get caught structuring a transaction, and why the hell can't you hire a lawyer without having the lawyer himself commit a felony? The criminal justice sanction actually works pretty well for most of us. It makes us be very, very careful in our practices. So we need sanctions, but we also need an honest mechanism to correct the errors. Just the plain old errors when those errors occur. And in the 5 boroughs, we have only one functioning conviction review unit, conviction integrity unit, and that is Ken Thompson's unit. Cy Vance's unit is really, as I've said before, it's a Peshima shawl. It's the latest fashion accessory, but it doesn't actually function. Thompson's unit, as we know, does function. It can be improved, and I have a number of suggestions. But let's face it, Ken Thompson, in taking office, has exonerated more innocent people than any district attorney in the history of the 5 boroughs of New York, and he does deserve, even from us critics, a shout-out, but those systems need to be made better. It's not about people. It's about institutions.
I'm going to jump in and say one thing, and I agree with most of what Ron says, as I normally do. But I think the most extreme cases where you're dealing with misconduct, actual misconduct, I hate to say it, those are the easy cases, and those are cases that do merit, some kind of punishment and some kind of penalty, and you have to police those cases. The area I think that you're talking about, which are more difficult, that were alluded to a moment ago, is either the negligence or the prosecutor, for whatever reason, not knowing and missing something. And those are the hard cases. because those are the cases when you're going back to the same office and asking them to look at it. You get the same kind of review, and I don't mean to be glib about it, but if I go to a muffler shop, and again, I don't want to be glib about it, but life ain't that complicated. When they don't fix my muffler properly and I go and say, take a look at it, and it's the same guy, he says it's fine. You're the problem. And so you end up with the same dynamic here. And look, I think what's going on in Brooklyn is admirable and it's great. There is clearly was for a long time, troubling doings with these convictions. But what becomes complicated is how do you institutionalize that when you're reviewing your own convictions?
Right.
Well,
That's where you get into trouble.
People think that the Derek Hamilton case, pardon? The
himself.
actual innocence claims. Yeah.
As co-members of the bar, it seems to me to be rare that informants and criminals tell what's going on every day. There's no system that tells when police officers are corrupt. Scarcella did what he did for a long time. Lawyers like Kuby and others cross-examined him. Mr. Cohen said he was aware of him, yet there's no database that track rogue prosecutors or police. I think if there's a database that's put in the system that when cops do something wrong, prosecutors do something wrong, that is ended, so defense counsel, members of the bar, everybody know about it. I think that will let them know that they're being watched.
You're absolutely right.
I think that, everyone knew that Scarcella was no good, like they knew other cops were no good. We can come and talk about it. We put systems in effect that allow defense counsel, when they cross-examine them, that this cop did this in 10 cases, or this prosecutor did this in 10 cases. Then you can understand that the jury won't believe him to be God. Scarcella testified in my case, he was more credible than the witness that lied on him. He got the witness. But judges knew that he was a liar. And they said it. So the point I'm making is that as society, as people in society, as members of the bar, we should pool our resources together, get a database, and chat a little bit. Prosecutor so-and-so did this in this case. So we can all share that information and probably shun them if they do something.
Well, it's good that we live in a time of technology that makes that sort of thing possible. I think, in the 90s there was less. I mean, even the Securities and Exchange Commission wasn't keeping track of all the different complaints that they had, and they just started. So there's hope, I think, for some sort of database. Yeah?
My name is New York Exoneree from MacAndrews. I served over 18 years in prison. I'm here with Jonathan Fleming as well, another exoneree. And the struggle that we all face as exonerees is not only seeking to hold corrupt prosecutors accountable, but also receiving compensation after a horrific experience in which we really almost lost our lives and in many instances has been destroyed.
Amen.
5 years I've languished without compensation while my wife and my children are suffering. Jim Dwyer wrote about my case in 1994. The case that won't go away, or it's still not going away. Mr. Dwyer. Mr. Kuby, I've written letters on behalf of Johnny Hadley to get him parole and get him his freedom. I'm an advocate because that's all I know now in light of what's happened. And all I seek is for justice and closure in my life after 18 horrific years in New York State maximum security prisons. What are we going to do about streamlining the compensation process?
Could I ask you something, Mr. Bermudez? Are you in the Court of Claims or are you in federal court?
I'm in both.
You're in both. And is the Court of Claims procedure also hung up, or is it waiting on the federal court?
New York State Attorney General's office, who supported me on my release under Eric Schneider, is fighting tooth and nail, even though he supported me when I first got out, and I did campaigns with him and everything.
Wow.
Yeah.
Okay, well, thank you for coming.
Look, let me just pick up on one thing you said, which is absolutely right, which is the system that exists in New York to evaluate not the claims against the prosecutors, but simply the Court of Claims cases, which are managed by the Attorney General's office. There's an inherent tension. It's the same tension we've been talking about all night. And so you've got an AG's office that is evaluating bases to release people for all sorts of reasons, and yet you have to go to that same group of lawyers, maybe a different unit, to evaluate what the appropriate compensation is or whether you should litigate it. There's no reason why the state can't set up a fund and people make claims against that fund. You're absolutely right. But it requires that people get involved, that people go to folks like Jim Yates and push for these kind of issues, because you're not heard in Albany.
Well,
Yes.
but there is such a fund, Steve. I mean, this was the law set up after the famous case of Zimmerman, right? Zimmerman was this innocent guy, went away forever and almost got executed, I think. And then when he finally got out, he had to fight for years to get money, and the state finally passed a special bill to give him some money. The poor guy died 6 weeks later or something like that. And and then they institutionalized it, and they put in the court of claims. It was supposed to be like no-fault insurance, right? If you're wrongly convicted, you get paid.
Except you have an AAG on the other side of the case.
And it's been every AG since I started covering this issue. I mean, I don't know about Capel, but Vaco, whoever, all these guys who came after him, they all have taken these stubborn positions against compensation. It's astounding to me. It's thwarting the will of the legislature.
Ron has something to say.
Yeah, this is sort of it's a touchy subject, because for a long time I advocated very simply, basically what Steve said. Look, we saw the 9/11 fund, right? Managed by help me here, I'm having a brain fart. Anyway, the guy that did it did a really good job, huge pool of money, and look, people. Yeah, thank you, Ken Feinberg. Thank you. People got a big pool of money, and it was great from every perspective. You didn't lose your right to sue. You could still sue. But you made a claim. Your claim was evaluated. You didn't have to pay a lawyer a third of your claim. So the amount of payment that went to you was more money, which means the fund saved money. You got your money now, rather than fighting the office for years, where they hoped that you would actually be desperate enough to go out and commit a real crime, and then your claim would be reduced without the bitterness, without the rancor of battling year after year and being recriminalized in the course of depositions. And I thought that was just a great idea. But the truth is, with a few exceptions, most of the private lawyers who do these cases these days, who win the exonerations, are looking for a payday. And they know that, okay, I've got Mr. Yarbough here. I think he's an innocent man. I'm doing God's work. I am. But I want to do good. But I also want to do well. So I'm taking his case because I think that not only can I get his conviction overturned after donating, and Steve knows this better than anybody, hundreds, thousands of hours without compensation. I know that there's going to be compensation at the end of the rainbow. I'm going to get my third of $2 or $3 or $5 or $6 million, $41 million. And that encourages lawyers to take these cases, private attorneys to take these cases. If you don't have that built into the system, then you're completely out of luck, because there's no other mechanism to provide you with counsel. Look, I never expected to ever I didn't even know you could sue when I did my first wrongful conviction case, the one that Jim talked about, Faison and Shepard. I just thought it was like a really cool case. But, you know, I'm privately funded through a radio show, so I don't have to make money practicing law, which I'm really good at, by the way, not making money practicing law. But most people are not in that position.
Okay, thank you. So this took a turn that was sort of unexpected. We have time for one short little question.
I would ask Commissioner Bratton and Mayor de Blasio to institute recording of interrogations and double-blind police lineup tomorrow, because we don't have to wait for the legislature. Barry has been back many years, and all those legislation. And Jim, please, let's ask them they can do it tomorrow.
Agreed. Okay. Babe, did you want to say something very quick?
Having watched, as many of us have the Adrian Thomas confession cases and many other confession cases, they're often on videotape. You can see threats, you can see promises, you can see them telling a kid, you'll go home, you can see it in the Central Park 5 page. On top of videotaping, we also need a set of rules.
Amen.
Will have to be legislated because the courts have said essentially that police can have kind of soft threats, by promises, deception. We have to have a set of rules that do not permit that kind of questioning, leading questions, feeding the answers,
So this is a, wait.
Even a guilty person, if a person's guilty, they may tell you a lot of false information and not say, yeah, I did it, but usually if you just check that story, you can then discover this person is guilty. So you eliminate false confessions, and false exonerating statements will essentially convict people as prosecutors well know and police will.
So this is the subject of the law review article I wrote. If Albany would ever give me hard copies, it would be good. But anyway, it's called An End to the Use of Lies and Trickery in Custodial Interrogations. And the point is, a lot of police officers think that it's legal under the Supreme Court precedent to tell a lie. And frankly, that's a very limited case, and the New York Constitution is broader than the federal Constitution, and there should not be people being lied to in interrogations because it's a big risk factor for false confessions. And now, D.A. Thompson, if you could join us at the podium.
Thank you.
I just wanted to stop by just to say a couple of words about what we're doing in Brooklyn. Obviously, there's no perfect way to review these wrongful conviction cases, but I think that we are on to something in Brooklyn, and I hope you'll just let me explain what my thinking is. First of all, thank you, Dorothy, for allowing me to come here tonight. I inherited a mess in Brooklyn when I became Brooklyn DA. When I was running for the office last year, I told the people of Brooklyn that I felt that Brooklyn deserved better, that we should not have a reputation as a place where people were being framed for murders that they did not commit. And if I was fortunate to become DA, I would do all I could to restore public trust in the integrity in the criminal justice system in Brooklyn. And that's what I'm beginning to do. Now, when I took office in January, I actually became the DA of the third largest DA's office in the country. Many people don't realize that because Manhattan gets all the play. But the Brooklyn DA's office is the third largest behind Los Angeles and the city of Chicago. I have over 500 prosecutors. I have almost 1,200 employees. But when I took office in January, there were about 100 cases at that time of wrongful conviction claims. But yet there were only 2 prosecutors when I walked through the door on January 1st who were responsible for reviewing these cases. Now, we sit on 10 floors at 350J. Those 2 prosecutors didn't even sit next to each other. They were on different floors. They weren't even given the real resources to investigate these claims. They weren't given what we have a bunch of internal investigators, we call detective investigators. We got about 70 of them. They weren't even given one full time to work on these cases. So I thought that was crazy. And so what I decided to do was to put a real unit together, because my predecessor called it the Conviction Integrity Unit. But I thought the process in place did not have integrity. And so I changed the name and called it the Conviction Review Unit. And I put together 10 prosecutors who no longer prosecute cases. They come to the office every day to review these claims. And I put together a team of investigators who are assigned to the Conviction Review Unit permanently. And they all sit together on the 20th floor at 350J. I'm on the 19th floor. But I also did something else that I thought was key, and that is I was able to convince a very prominent law professor from Harvard, Ron Sullivan. I was just with him in the office. I wish he could have been here with me, because Ron Sullivan, I think, is the answer, Steve, in part. I heard what you said about a DA's office can't really investigate these claims. I think we can. And the way I'm going about it is Ron Sullivan, he is a defense attorney. That's what he was in D.C. when he had helped advise President Barack Obama when he's running for president on criminal justice issues. It was from the perspective of a defense attorney. He's a professor at Yale Law School. Now he's running Harvard's Criminal Law Institute. Professor Sullivan has agreed to be my special counsel to run my Conviction Review Unit. And so with Professor Sullivan at the helm, with prosecutors who understand that they have a DA who's determined to get to the bottom of these cases without fear or favor. And then I also put together an independent review panel of attorneys who don't work for me. They're in private practice. One is Bernie Nussbaum. Another one is Gary Villanueva, defense attorney here in the city. Another one is Jennifer Rogers. Now, at the end of the day, in 11 months in office, I have moved to vacate about 10 convictions. I think that is extraordinary. And when I was planning this unit, from January till about May, I was hearing complaints from Ron, Kuby, and others, saying that I promised that I was going to run on this. What was I doing? I don't think they realized that there was really nothing in place. Because when I was on the outside, I thought that there was a real independent review panel. They had not done much. And so I had to build this from scratch. And so the first thing I did was, without hesitation, when I could, I moved to free Anthony Yarbough and Sharif Wilson, without even having a independent review panel in place. And then shortly after that, I moved to free Jonathan Fleming, who's sitting right there. So I am dealing with a staggering number of cases, over 100 wrongful conviction claims in Brooklyn. At one point, we had 130 of them this year. And 71 of them involved Detective Louis Scarcella. That is extraordinary. So I just want to tell you that in terms of what I'm dealing with, it is a new day in Brooklyn. It comes down to the will of the DA. I can't speak about anyone else. I've been invited to speak around the country, and I've been going to Dallas and to Chicago last week, because I think it's important to get to the bottom of these cases, and everyone is not going to agree. We've been through 30 cases so far, and the majority of the cases we're standing by the conviction. The evidence is overwhelming. But in the cases in which we've concluded that men were wrongfully convicted, I'm not afraid to make that decision. 2 weeks ago, I moved to vacate the convictions of David McCallum and Willie Stuckey. Now, why is that important? It's important because they were 16-year-old boys from Bushwick who were accused of going all the way to Ozone Park, Queens, and abducting a man named Nathan Blenner at gunpoint, driving him to Brooklyn, driving around in his car for hours, taking his credit card and filling up his car with gas, and then taking him to a field and killing him, and then driving his car around for some more for days. And they were convicted despite the fact that there was no evidence. There was no physical evidence, no DNA evidence, no fingerprint evidence, no testimonial evidence. What it came down to was a videotape confession, short videotape confessions that these two young boys gave. I mean, we had never seen videotape confessions like that before. They were so perfunctory. They were inconsistent. They both pointed at each other. And so we could not save Willie Stuckey because he died in prison of a massive heart attack at the age of 31 while maintaining his innocence. But I got a letter in January from David McCallum's lawyers asking me to review his case. The same evidence that they presented to the prior administration. And they told me that the prior administration, as they were heading out the door in January, told them, come back to us when you find the real killer. So I took that evidence and I looked at it for 10 months, and then Hurricane Carter wrote a letter to me on his deathbed, but we had already started to look at the case. And I concluded that I believed that those confessions were false, that they were based on false-fed facts. And so I moved to vacate their conviction. And so I have other cases, and I see some of them are in here that are waiting for decisions. We don't have all the answers in Brooklyn, but I do think we're on the right path because it starts with the DA. Now, I can't say that there will never be anyone wrongfully convicted under tenure, but I can tell you that I'm going to take swift action. I brought all my chiefs together. See, it's not good enough just to clean up the mess that I was left. We have to prevent this from happening going forward. And so I told them the days of wrongful conviction in Brooklyn must come to an end, and we have to hold each other accountable. And so I am determined to do what I can in Brooklyn And hopefully other prosecutors will look at their cases as well around the country. Because no one in this room should want an innocent man to spend a day in prison for a crime they didn't commit. When I called Willie Stuckey's mother to let her know that I was going to vacate his conviction, she didn't exactly know what the purpose of the call was. We could not bring her in, so I had to do it by phone. There was other family members on the phone, and I told them that, I explained to her that I'm the new Brooklyn DA. And I wanted to talk to her about Willie, and I said, Willie should never go into prison. And we're going to vacate his conviction. All you could hear, all I could hear on the other end of the phone was Willie Stuckey's mother crying uncontrollably. Because she said her son wasn't 16 when he was arrested, he was actually 15. And she had maintained that she knew he was innocent from day one. And so I said, we can't give Willie back. We can't get him back, but we can give him back his good name. And I asked her if she would come to court the next day and stand in Willie's shoes. And that's what she did. And I think that it's true that there is a mentality with some prosecutors. But I'm hopeful that you can look at the model that we're putting together in Brooklyn, which is, when you talk about the institutional bias, I turn to someone like Ron Sullivan, who doesn't have that institutional bias. I turn to this independent review panel. They give me their recommendations as well. It's not binding on me. I make the ultimate decision. And then ultimately, I think I put together a team that understands my conviction review unit is not in the basement of 350 J Street. It's on the 20th floor. It's up there for a reason. And so I'm here to tell you, I can't defend every prosecutor, you know, but I can only tell you that in Brooklyn, we need to lead the way in the country, because we cannot have innocent men going to prison in Brooklyn or Manhattan and anywhere else. And I'll take the hits, I'll take the criticism, because I think that I ran for a reason. And I think that if I didn't win, I'm not sure that there wouldn't have been other people passing away in prison. I couldn't get to Willie Stuckey in time. I couldn't get to others in time. And so I'm going to call it like I see it in Brooklyn. That's all. Thank you.
Thank you, DA Thompson. Thank you, panelists, for agreeing to come and actually coming, and thank you all. Good night.